right, so good morning. I know we've got an hour left. Usually I say good morning the whole day through, but I'm still in the morning, which is a good thing. Can you hear me? Is that okay? Okay, perfect. All right. So as Fran said, my name is Jennifer Stewart. I'm at the Larimer County Attorney's Office. I send lots of subpoenas, like I send subpoenas every day. And I know people hate receiving subpoenas. So we know as attorneys how much you dislike us. That's okay, it comes with the job. It's not personal, I don't take it personal most of the time, because when you meet me, then you go, oh, you're not so bad. Let me just describe kind of a little bit of this process. So in our interactions with the Department of Human Services, the department often uses SummitStone for most of its treatment needs. Okay, so the Department of Human Services sends over children as clients, and families as clients, and parents as clients, and grandparents as clients, and anybody that we possibly can as clients. And often, the Department of Human Services does not, I should say most of the time, when the Department of Human Services is involved, it does not necessarily end up in court. Okay, so the Department of Human Services, in their about 45, I think there were 4,500 different referrals that they went out on, only about 5% of those ended up in the court process. And only about, of that 5%, about probably 20% ends up going to trial for one reason or another. And so chances are you're not going to be subpoenaed for all of the work that you do, okay? Chances are most of the work that you're doing isn't going to be, for lack of a better word, in court. On the off chance that you do get subpoenaed, there are also lots of times that we don't end up going to court. And so we usually try and resolve cases. We work really hard to try and do that. And so even though we may have subpoenaed you, there also is a possibility that we won't end up going. And so one of the things I try and tell people about is that to recognize that we want you to be prepared, we want you to have an understanding of what's coming up and what our expectations are, but that there's a possibility of resolution. And so we have, I guess, for lack of a better, I don't know why I keep saying lack of a better, but it's going to be my key phrase, I think, for this presentation. But there I go again. What I guess I really want you to know is that there are lots of times where you may get a subpoena, but we don't end up going to court, okay? When you get a subpoena, SummitStone has graciously allowed us to try and make this process not as terrible as it could be. We've had a number of meetings with the administration so that the subpoenas you aren't getting process servers knocking on your door and demanding to see you so that they can hand you a subpoena. We've tried to make that process as seamless as possible and give you as much notice as we possibly can. And so we have some expectations that we need to send the SummitStone's whoever's looking at the email. We send it through email, and that counts as service. So it comes through an internal process, which is a good thing, I think. It was really rough when we were trying to have process servers constantly interrupt. So we have stopped that process and hopefully made it more smooth. We also try and give at least 14 days notice. And if possible, we try and give as much notice as possible. So right now I'm setting cases out between 30 and 60 days. And so I'm already sending subpoenas out that for trials about 60 days from now. So we're trying as much as possible to give you as much notice as possible. When you get those subpoenas, on the subpoena, there's a cover letter that says, here's the person that we need you to contact in order to make an appointment with the attorney who's trying to subpoena you. There are in that, when you get a subpoena, you're going to talk to Fran. There's going to be a whole internal process about whether appropriate releases have been signed, whether you can talk to the person or not, how to go about that process. So Fran and I have had a number of discussions about if there isn't an appropriate release, how we learn about that information so that we can make sure that we either follow up and get an appropriate release signed or we get a court order. So that the information so that you're still covered, but that we are also getting the information that we need to. So you'll have that conversation with the assistant of the paralegal. Also on there is sometimes a number of dates. So sometimes a subpoena comes with, we need you to come on March 14th, 15th, and 16th. When you have the conversation with the attorney, that attorney is going to be able to limit it to probably one of those days in your first conversation. And then in follow-up conversations, when we get closer, we try and limit it to a morning or afternoon, or here, I'm going to need you to show up at 9 so that you can leave and be done by 10. I mean, we really try and work with your schedule. So if you have a day that works better out of those multiple days, or time that works better, evenings are hard. Well, evenings wouldn't be court involved, but afternoons are hard, mornings are better. We can work around that schedule. We just need to have that communication. So I need to know what it is that I'm working around with your schedule, and so that we're not taking so much of your time. I want to be respectful of that time, but I also need to make sure that the court hears the information that regarding the case that I believe is important. Any questions about that so far? Okay, all right, that sounds good.
I'm just kind of curious.
Yeah.
So I know you're working with Department of Health and Human Services.
Mm-hmm.
Is this something that we can expect if other agencies also are looking to subpoena too?
That'll be totally separate conversation.
Okay. All right.
This will just be with Larimer County Attorney's Office or DHS.
Okay.
Right.
Thanks.
Is what we're talking about today. And just so everyone in the room knows, and on Zoom, it won't just be Jennifer Stewart. There may be other attorneys. There's 3 or 4?
There are 4 in our office.
There's 4 attorneys in her office. So if you see a different name, they're still part of that process.
Yes, absolutely. So let me just say, it's just a quick answer. It's not generally the same process, but most attorneys are pretty amenable to having conversations about what time frame or what your restrictions are. The other thing that I want you to know is if you are on vacation, or if you are out for surgery, or if you are, something is prohibiting your ability to be available any of those days, or any time within that time period, then we really need to have a conversation about whether a supervisor could testify for you, or how then I try and resolve those concerns. So the sooner I know, the better I can address it. Every once in a while, I have somebody who says, well, I'm going to be in a training in California, over those 3 days. And sometimes I get to have them testify by telephone. They don't like it, but but at least then, your information is coming. We get a really specific time, and everybody knows that you're going to be able to testify by telephone. So we try and think creatively about how not to interfere with your schedule and your responsibilities as much as possible, while still communicating what evidence needs to get before the court. For the most part, the Department of Human Services may gather records, but our office, the records that we typically look for are your analysis reports or discharge summaries or the integrated assessment. So we're not looking for therapeutic notes. We're not looking for the treatment plan or those type of things. For the most part, I'm really expecting, and I'm not going to be presenting much paper information to the court. The only time I may be looking for paper information is if the client had seen multiple therapists, and kind of was a yo-yo client, coming in and out and in and out and in and out, and lots of people have disappeared since then I may need to show a progression over time. Again, that information is really very useful to be able to have that conversation where you can say, hey, I only saw this person twice, but I saw that they came back and saw this other person, and then I saw that they came back and saw this other person, and then were discharged. It really helps to have a whole piece of information so I can decide whether you're necessary or not. Sometimes it's if you've only seen the client once or twice, then I may not need you. Sometimes though, that's all that they've done, and I need somebody to come in and say, no, they only came in twice, and we didn't even get to decide on our goals because they were in and out, and we were just trying to explain the rules, and then they didn't ever show back up. So just because somebody has come in once or twice doesn't mean that you'll be released, but it also is, there's a better likelihood of being significantly able to reduce your time frame in court. We can usually get you on and off the stand for about within 30 minutes. So we're trying to be then very cognizant of there's not much, but that information is still very important. Any questions about that? Okay. When you come in, the reason why the Department of Human Services has sent the client over to SummitStone is because you have a certain expertise. And so when I talk to most SummitStone practitioners, all of you say, well, I'm not an expert. And you are. The long and short of it is it's really, you have training, you're here for a specific reason. You have experience as a therapist. You've been treating this particular person or their family. You've been working. You may not have an expertise in the sense that you can go and teach, a college, course to other professionals in the field. But you do have the expertise in that you know what it was that you were doing and what your recommendations were. And as a professional, you have that education and experience and training necessary to make those recommendations. So take an integrated assessment, for instance. An integrated assessment has recommendations as to the treatment that's being recommended for this particular client. That recommendation is requires an expertise, both in an addictions counseling and in mental health, that you are able to review those records and then make the recommendations. So that has to come from an expert opinion. So when I'm working with you, I'm also going to be trying to qualify you as an expert. So one of the first questions that I ask, the first question I ask while you're on the stand is, please state your name and spell your last name for the record, just so we can establish who you are. And then, so just as a side note, if any of you are practicing under maiden names, I need to know your legal name. So when you're swearing to tell the truth and nothing but the truth, I need you to say what your legal name is. So if it's not the name you're practicing under, we just want to have a conversation about that. That's it. I just wanted to put that out there. But the second question I ask is, what is your profession? And have you ever been qualified as an expert before? If you haven't, that's still okay. And then we go into what is your education background? How many hours have you been working towards licensure? Do you have any licensures? Have you been certified by the state in any type of specific training, that type of thing. So I'm looking for just kind of your training and education background. The court will more than likely qualify you as an expert, because all that's required here on our piece of paper is that anyone through education, experience, or special training has more knowledge than the average person. That's the definition of an expert for legal purposes. So I want you to know that and have some confidence in, okay, I can make these opinions because I just have to know more than the average person. And you do. Yay! So for court purposes, even if there's an objection by opposing counsel, it's, for the most part, courts go, well, you have the requisite, education, training, and special experience, so I'm qualifying them as an expert. Even people who are in training, you still have the education, you are still going through your training, you've been talking with your supervisor who has been certified, so you have, again, it may not seem like a lot, but you have more than the average person. So more than likely, you'll still be qualified as an expert. So when you come in to testify, the one thing I guess that I would say is that when you're there, be prepared. Our office tries to send questions a week ahead of time. Sorry, Mary. We try and send it a week ahead of time. Sometimes it may be more like 2 or 3 days. But for the most part, it's the same as the conversation we've already had. So in our conversation, I'm asking, when did you start meeting with the person? What were the goals? Did you see progress on the goals? Did they successfully finish, or were they discharged? What was the outcome? And what was the attendance? I'm trying not to get into any statements that they've made. I'm trying not to get into any statements or opinions. I find that most therapists are worried that we're going to ask opinions about whether you believe this child should be with this family, or whether you believe visitation should be occurring, or whether you believe this person is can maintain their sobriety. I'm not, and our office tries really hard not to ask those particular questions because we know that that's not your role and not your responsibility. But we are going to ask questions that say, how do you think therapy went? Did you see any changes in the behavior or the interactions? If you're doing family therapy, did you see any changes between the parent and the child? Any improvements? Did you have any concerns? And if so, were they, and how did you try and address them? We might also ask, if you're doing individual counseling, what were the goals that they identified they wanted to work on? And did they make progress? Were there any barriers that you were noticing? So sometimes in my conversations with Mary, we've had homelessness be a barrier to progress, where they had identified goals, they could show up every once in a while, but homelessness was a real factor in their ability to attend and actually practice some of those skills. And so that was something that was noted, and then we can say, okay, did you bring that up with anybody at the Department of Human Services to try and address, or make a referral to a peer counselor? How did you try and assist to overcome those barriers? So it's really about your work with the client while not trying to get into what was said. And so it's a lot about what progress that you saw or didn't. Were they successful or not? And recognizing that it's just within your purview of when you saw them. So you can't, and there's nobody that expects you to be able to say, this person's going to be great from this point forward. I fixed them, okay? Nobody expects that. And we're not, there isn't going to be that type of expectation. But what we do want to know is whether the person was making progress, whether they were talking to you about, here's how I practice this skill. So sometimes in anger management, clients will say, hey, I had this situation come up, and here's how I dealt with it. How do you think, was that the right way? Or here's how I practice the skills. And you don't have to tell us exactly what they said, but just said that they would report how they were practicing their skills in their everyday life. And that helps give a sense as to their participation in treatment and whether they were trying to improve in some of those expectations of the Department of Human Services. So we want you to be, when we're having a conversation, that's typically what my office is trying to gather. We're trying to gather that information about whether what you saw and what you heard and what you believed through your work with the client. Does that make sense? So we'll have that conversation, and then typically for court, it's very similar, but it's typically in a better order. So I've now had that conversation with you instead of going back and forth about, so tell me about the goals, and then you go, hey, I forgot about this particular thing. We go in a more sequential order. And I try and send you questions ahead of time so that you can feel some confidence in, I know what the answers are to these. I already know that they're going in a direction that I'm okay with. If there's a question that we send you and you don't feel comfortable with it, please tell us that. It really helps us to identify why it is that you don't feel comfortable with that particular question. Is it asking you something that you don't feel you can have an opinion on, which is fine. We just need to then have a conversation about how I can either change the question so that it reflects what answer I'm trying to obtain, so that it's in a purview you think you can and have the ability to answer, or I can take it out and I can say, you're right, that's a question that I don't need to know the answer to, or I don't know that the court needs to know, or that didn't go in the direction that I wanted it to. So we're just going to take it out. So if you have concerns about those questions, please review them ahead of time and let us know. The more confident you feel in knowing the answers and in that I can answer all these questions and that's not going in a direction that I'm nervous about, the better on the stand you are in communicating to the court what progress or lack of progress a person made. And there are some times when I'm calling you and you've got really good things to say about a parent, or about a parent and child relationship. That doesn't necessarily mean I won't call you. It means that I really want to make sure that that information gets heard in front of the court. And that, so for instance, I have a case where the parent and child did really well in parent-child interaction therapy or theraplay. I think it was theraplay. But when the parent would go to the supervised visits, they weren't practicing any of those skills. And so I wanted to have still the information, the court had that information that the parent was being taught those skills, was practicing those skills in the theraplay, was working with the child and demonstrating that affection and helping through some of those therapeutic needs. And then I also need the caseworker to say I wasn't seeing that being practiced outside of that ability. So you can't say that, but I've got somebody else who can. And so all of the information is important, and it's just a piece of the puzzle. You have a piece of the puzzle that I want to make sure that the court hears. So I want you to be confident coming in. I can't tell you how many times therapists have come in and they are more nervous than anybody else in the courtroom. And you have the skills to deal with that. And it's really funny to me sometimes because I'm like, okay, take a deep breath. We're going to pull out our skills. And what is it that helps you? If I write questions ahead of time, if we talk ahead of time, how are we going to, So I am not a practicing therapist, but it is pretty funny that I go, okay, what skills would help you to make it through this process? Because I recognize that it's nervous and you're nervous, but it is actually really funny to me that sometimes therapists are the people most afraid to be in the courtroom, and you have the skills to deal with it. Yes.
Actually, let me just interject there because I've done this several times now. My nervousness is not with you because I get to talk with you. I get to have your questions.
Yeah.
My nervousness is not knowing what the defense attorney is going to say.
Right.
And I think that maybe you can help us with that piece a little bit because that's the big unknown is, I know what I'm saying to you, and I personally take her questions and then I just write my answers under each of her questions so that if I do get nervous, I have a piece of paper, I can look at the question and I can ask the judge to read my answer. But what I don't know is what they're going to ask.
Right. Okay, so let me just rephrase that a little bit. Absolutely. The parts that I can assist with but can't give you all the answers to is what the opposing parties are going to say. Because I just don't know all of their trial strategy, and I shouldn't. And so I can give you ideas, what I think they're going to say, and let me take a step back. So Mary Jane was just saying that part of the nervousness is not knowing the entire process. So what other questions could be posed, and whether that's going to be in an area that's comfortable, and how do I still answer those questions but still stay within my parameters and my expertise. All of those things are absolutely valid. And so when we are having our conversations, 2 years ago, we had a number of changes to respondent parent counsel and the guardian ad litems. So for a while, our office was not able to say, here's how this person asks questions, because we didn't know. We were learning their trial strategies and their as fast as you were type of thing. But now we have a better idea. So I'm better able to say this attorney is going to try and pick on this one particular issue and dive down and see. So for instance, I can give you an example. Ms. Palmer has been working in this field for 26 years. And she'll
Does the majority of the cases for the most part. So
Yep.
You're gonna run into her.
Yeah, and so Ms. Palmer, her favorite technique is to take 2 or 3 areas and do a deep dive. And so she likes to say, so if you had, if you were doing individual therapy, she might go, well, these were the issues that the client identified, and they were working on them, right? And she gets really good in having questions that require a yes answer. And then she'll switch at the end when you are used to saying yes, and then she'll go, I'm not kidding, and then she'll go, well, isn't this then a possibility? Can't you do, can't this person be ready within 3 months? And you're so used to saying yes that you just say yes, and then I come in and I go, okay, great. Now that they can do it in 3 months, that means that they have to show up consistently, right? And they have to. So I can then get back to the questions that we were asking and get back to a sense of not predicting where a client's going to go or how fast they're going to get there. And so it's not. It's a nerve-wracking moment. It's hard to be under the spotlight, which is why I say on my tips and tricks, it's kind of like an interview process. When you're going in for a job interview, you're not quite sure what the employer is going to ask or how they're going to ask. You know that it's going to cover this range of topics because that's what the position is for. It's kind of the same thing where you're coming in and one person is friendly in the interview and you're not quite sure about what the other people are going to do. For the most part, the guardian ad litem is also going to be fairly friendly if they ask any questions at all. The guardian ad litem is most going to be interested in if we're calling a child's therapist or the family therapist. Mostly because they have a lot of information, they've had a lot of discussions. More often than not, they kind of hold the privilege or have been talking to the parents about the privilege or have been talking to the child, depending on the age, about the privilege. So they have a lot of information, they know what's being said. We've often had conversations ourselves, not necessarily in your presence, about what our parameters are, what areas we should not go into, to how not to ask something about what a child has said, that type of thing. So we're trying very carefully to walk that line to not invoke privilege or to have that become an issue. But that's when guardian ad litems typically become more involved in that, court asking questions. Respondent Parent Council do have their own tics, and we've had enough time that we start to understand their tics. Like Mr. Van Gasbeek, he's very loud. So when he talks, it seems like he's yelling. He acknowledges that, and so there's every once in a while we'll stand up and we'll go, okay, this is getting a little loud, and because he's very passionate and he gets really loud. And the microphones are really good in the courtroom, and so you can hear him very clearly. And so then he takes a deep breath and he tries to take a step back and he tries to calm down and use his own skills to make sure that he's doing a better job. But so those are some of the things that we've started to learn over time, and we can then help you through, depending on who the Respondent Parent Council is, what we expect them to kind of focus on. I won't be able to tell you what their questions are, but I usually have a sense, at least a week ahead of time, where I think they're going to go and what questions I think they're going to ask. For the most part, if you haven't had much interaction, most Respondent Parent Council won't ask you very many questions. They may just say, well, are they welcome to come back to SummitStone? And you can say, sure. At any time, they can do a re-engagement process. And then they're done, and you can sit down, and it's all over. Yeah.
So I have a question. If you were subpoenaed but then the client does not sign a release giving you the authority then to testify, what is that? Can you speak to that process about what would happen, or you still have to show up, or
Yep.
what does that look like?
Okay. So if you have received a subpoena and the client does not either had a valid release at some point and no longer is there, or doesn't have a valid release, then there's a couple of ways that we go about it. I still want you to call our office and have a conversation, but in your conversation you can just say, generally, here's what I do when I'm working with clients in general. At that point, I know you can't talk to me about the specific client that I'm pretty sure has been in your office, because the Department of Human Services sent me your name. And so then I have conversations about whether the Department of Human Services has a release and whether they can then obtain records so that I can figure out whether I need to have you testify or not. The other thing I do is if I still need to have you testify, then I go to court and their HIPAA obligations. And I haven't seen the court deny that order yet. And so the expectation is that you still come. We're going to try and address those issues as fast as possible so that you have some notice of that. There are times, though, when the court delays ruling on it until it can hear from the opposing side as to whether they have an objection or not. Oftentimes, Respondent Parent Council are also trying to get their clients to sign a release or to agree because they know I'm going to get there anyway. And so we're trying a whole variety of methods on our end to be able to cover you from that process. If the court ends up saying no, then I will just let you know and you are released at that point. Does that answer your question?
Sort of a follow-up question. So if would it be then you would get this ahead of time, or would it be like I'm up on the stand, let's say, and you asked me the question and I say, I'm sorry, I can't answer that because I do not have permission to disclose that. Would then the judge overrule at that point?
That has happened. And usually that happens when our court process is going fairly fast. So every once in a while there's a hearing that comes up and it's probably 3 weeks that we have notice of it. Sometimes that can be a change of a protection order hearing or that type of thing. And so if we are coming up fairly fast and we don't have a pretrial conference, we'll have written our motion and had all the parties respond to it, but the court may wait until that trial date to actually make that decision. So every once in a while that will happen. But the more notice I have that you don't have a release, the better off I am at trying to get that order ahead of time. And so that's, I have experienced sometimes where practitioners because of the release issue, then have lots of conversations internally, but don't communicate the issue to my office for a variety of reasons. And then I find out maybe 4 or 5 days ahead of time, and that makes it really very difficult to have it addressed ahead of time. Usually the court will wait. So the sooner I know, so the sooner you call and say, hey, I can tell you generally what happens at SummitStone, and here's what I do with my clients in general, the better I know that I don't have a release or one wasn't signed for me, and so I need to go this other process and get there as fast as I can.
And just a follow-up to that, we did put all of that information in Summit Notes, and then if you didn't see it there, we have it all written out specifically to that.
Yep, it's kind of our secret code. Yeah.
So this is just, I'm sure this never happens, but what if a therapist fails to appear? What happens then?
So for a subpoena, the court will then ask whether I want the person, a warrant to be issued for the person's arrest if you fail to appear for a subpoena. So that is a remedy. Right. No, and really, just tell me. I don't want to do it either. But if I don't know, and I haven't had any communication, it is, I had one case one day, and I haven't had it since, thank goodness, but I had one case where I had 5 people who didn't show up, 5 witnesses out of 7. And it was a terrible day. It was if you've ever read the book, Alexander and the No Good, Very Bad, Terrible Day, that was my day. And one was in California, and he had forgotten. He had forgotten to tell me he would be out of the state, and he had forgotten about the subpoena, and he had been given 3 months notice, and I was like, ah. And another person was sick and also had forgotten to call our office. And so it was just this whole thing of events. I had one person who was in the office, and we were able to call them up, and they came then over. But there were 5 witnesses, and I was like, this is terrible. And so, the court asked at that point if I wanted, and then at that point, after so many people, I was like, no, we're just gonna go with the, evidence that I have and try and move this through. But it was a really bad day. And luckily enough, we were still able to get most of the information I needed to get out. But there are just some of those days. But there is some judges that will just issue the warrant. They won't even ask us. And so just be aware. It says it right on the bottom. And I just want you to be aware that contempt means that they may just issue a warrant. It doesn't mean you'll go to jail. It just means that they may issue a warrant. I will call you, though, and I'll tell you if that happens. If you are released, though, from a subpoena, there's... So I used to have this respondent parent counsel, Mr. Hefty, who would get really frustrated if I released witnesses without his permission. I don't have to get his permission to release people from my own subpoenas. And so he would then ask for a warrant, and the court would go, well, I'm sorry, did you subpoena the witnesses? And he would go, well, no, because Ms. Stewart did. And I said, but I released them. And so we've had some of those instances, but the court's never granted it on somebody else's request. It has to be from the person who is issuing the subpoena. I also have to show that I served you properly in order to do so. So if I didn't send it 14 days in advance and it didn't go about that normal process, then I wouldn't be able to ask or have anybody be held accountable for that. Yeah.
Hi, sorry, I'm getting questions from other sites. So they have a couple questions. So one of them is, with new technology, do you foresee the future of testifying by phone more common or Skype?
So I should repeat the question. So the question is, as technology continues to improve, whether testifying by Skype or by telephone is going to be more common practice. The The court process, well, the reason why we ask you to come in person is because you get a better sense of somebody else when you're sitting across from them. You can watch their body movements, you can watch whether they're reading from something. You have a better sense of somebody. I think it's when we are hearing the words or what somebody is saying, we pay more attention to all of the rest of their body and how they're communicating versus the words they're actually saying. So like 90% of what we see, and I don't know if that's the correct statistic, so don't hold me to that, but approximately 90% of what we hear comes from what we are also viewing as a part of their body. And the same thing for a judge and the same thing for a jury. And so if you are there in person, people have a better sense of the confidence they can have in your opinion. So Skype may be a better wave of the future because, again, it's visual and people have a better sense. Telephone is not as common, and we only use it in the instances where people are out of state and can't be in state, or they're far away, so you were in the mountains or that type of thing and can't be at the courthouse in those instances, because we still want the information, but they just it's not as interactive. People can't judge your credibility when you're testifying by telephone, so it makes it much harder. So I don't see telephone getting better or people using the telephone more in the future, but if Skype continues to get better and more reliable, and the courtrooms start getting that type of technology, then I see that happening. So right now, our courthouse has a screen like this, one for the entire courthouse. And so you have to reserve it months in advance. You have to have a sense, they have to practice. So they practice connecting. They have to download a program on your computer. Like it's not user friendly yet. So I anticipate that will be a wave in the future, but I think we're still at least 10 years out, if not further, from that becoming more commonplace. Any other?
Yes. Sorry.
That's okay.
Okay, so I'm going to read you verbatim what this means, and I'm sorry if I'm not able to elaborate. Do you know the difference in attorneys speak between being subpoenaed to testify and being asked to report on a treatment with a client in court?
Well, so the question was if I know the difference between being subpoenaed to testify versus being asked to report. Subpoena means you have to go. So subpoena is a court order in effect, which is why it can be you can be held for contempt because it's a court order to appear. If you're just being asked to appear and report, there isn't a requirement to go. Still may not want to not follow what the judge has asked you to do if they ask you to come, but it's not an order. So that's kind of the technical difference. If you're being asked to report, they're probably not swearing you under oath either. So you may not have to swear to tell the truth, nothing but the truth, and versus a subpoena, you're coming as a witness. You will be sworn under oath to tell the truth. So those are kind of the two main differences on how I would respond to that question. So hopefully that answered the question. Was there any others?
That's it so far.
Okay, perfect. Any other questions? Okay. Okay, so when we're looking for information, so I have on your sheets here, and for those who are joining us by the Zoom meeting, we'll send those out. So I'll send this kind of our tips and tricks to Fran, and she'll send it out to everybody. But we have, I want to make sure that people know what we're looking for. So we're not, again, I'm just going to repeat, we're not looking for often privileged information. So conversations that you want to keep between the client and yourself, that's fine. What I want to know is your impressions. So I want to know what your recommendations were. I want to know what the attendance looks like. I want to know what the goals that you're working on. I want to know what your impressions are. I want to know if you have any concerns. If you have red flags and if you address them. The one big thing that's kind of changing recently for the Department of Human Services is the diagnoses of clients. And the reason why that's a bigger thing recently is that the Department of Human Services in March was told by the Colorado Court of Appeals that they needed to know what the diagnoses were of their clients and be able to say how they tried to accommodate for those diagnoses. I don't want the Department of Human Services diagnosing anybody. They're caseworkers, they're not trained for that. That would be totally inappropriate. But because you are working with them and that is something that happens within your field, you may have a preliminary diagnosis, you may be ruling something out, you may be saying, I'm trying to better understand if I have a diagnosis here. Often it's substance use disorder is one of them. I often see anxiety and depression is another, whether it's minor or major or severe. I'm familiar that there's a DSM-5. I'm not familiar with what's in it. And so we may ask, and the Department of Human Services, we are now training caseworkers to have a better understanding of what it is that's specifically being diagnosed, because if there is a diagnosis and the department should be interacting with the parent differently, then we need to know that. The same thing is we need to be communicating with you if there is something that we know. So for instance, I had a case the other day where mom is dyslexic. And the parent's attorney said, hey, we want you to know mom is dyslexic. So anything that gets in writing needs to be verbally told to mom. So my instructions then were to the caseworkers, please make sure you write that down everywhere. And then communicate it in either with SummitStone, whoever's going to be treating this person, so that you know that information and don't have to discover it on your own. So that you also then have that information when you're working with the client, so you're not working with one arm tied behind your back. So we're hoping that the communication, that the Department of Human Services can kind of be a pass-through. So if SummitStone has, someone within SummitStone has said, hey, we have a substance use disorder and we have severe anxiety, that we also want to make sure that we're communicating that to the family therapist, so that if mom is really anxious and that there may be some more supports that we can provide for that family therapy, or that we're just communicating what those are, so that everybody's on the same page. And so that's one big change I think that the caseworkers will hopefully be following up with you on, but that's the reason why they're doing so. So the Court of Appeals has said, hey, you need to know what the specifics are and how you're going to address it. Any questions about that? Okay, I think any questions from out there, please email, because I think we're just about out of time.
I do have one question.
Sure.
So, and this didn't happen with your office, it happened with a different office.
Okay.
But we had two parents who both have the decision-making for the child.
Mhm.
The child was not old enough to do it themselves. And they were in a custody issue. And so the mother's attorney had an ROI from the mother. Father would not sign it because obviously.
Yeah.
And the attorney insisted that one ROI was enough. What is your take on that?
Okay, so the question is, when parents still retain that authority to consent for service and sign ROIs, and that the child doesn't have that authority and the parents still do, then is one parent's release enough? And the answer from my perspective is no, that one release is not enough if the parents have joint decision-making authority. If that's happening in a Department of Human Services case where we have parents that still have all of those decision-making rights and that authority, meaning the Department of Human Services hasn't taken that authority from them, then really make sure that you're communicating with the attorney that everybody needs to participate or a court order needs to happen. And so when I find out about that and the parents are disputing that, I just go and get a court order. I mean, honestly, our judges are more in the favor of, we need to make sure that we get all the accurate information and all the right information rather than having hidden pockets of information so that the court can make the right decision. And so I just go and get a court order. So, and honestly, I wish domestic relations attorneys would do that more often as well. So that would be my, I guess, take on that particular answer. And if we're having that problem in our cases, please just make sure you tell us, and I can solve that problem fairly rapidly. I'm not afraid of the court process. Yeah.
Sorry.
No.
Are resumes still being asked to prove that the clinician is an expert witness?
So resumes are not to prove. So the question is whether resumes are still used to prove the expertise of a professional. Resumes have never been used to prove in quotations the expertise of a professional. What it is that we ask for a resume so that we can send it to all parties so they're aware of what your credentials are ahead of time, so that they don't have to ask you on the stand, okay, when did you go to school and what did you get, and then where did you go to grad school and what did you get, and what professional. They just know through your resume what it is that if they have any questions about, you took 20 years off and went and became a tour guide for Mount Everest and then came back and only have been practicing for the last 6 months, they might go, okay, so what was that? And they might follow up on that. That's pretty good on your resume, so I'm not counting it as a detraction, but they're looking for things to be able to follow up on. Every once in a while, there's an expert that pops up that claims they're an expert, and then when you follow up with their credentials, they don't exist. And so sometimes that happens, and we just want to make sure that I don't put them on the stand. So I really would hate to have them swear to the information that is not true. And so that's why we have resumes. It's just to give everybody a heads up as to what your credentials are, so you don't have to go through that whole interview process. Any other questions? Okay. Breathe, relax. We'll help you through this. I'll help you identify your skills. And then we're good. You're welcome.